indicated if I then obtain legal representation, that legal representative may require an opportunity to prepare for the trial. Not to mention the applications that will probably be brought interlocutory before witnesses or during the actually.
So your hope is that by August you should.
Yes, Judge. That is the long and short of what I'm trying to explain. So the context of what I say, because and these applications.
And all I want to know is, you see, when we say August, I want to know that I shouldn't appear like I'm descending on you with a hammer. In August, the trial, are you agreeing that the trial must start in August with or without legal representation? Because if you make your applications this month and your applications are disposed of, and assuming you are unsuccessful, I don't know which applications you are going to mount, but if it is for the Section 26 application, the Mulima type application, all those applications would hopefully have been resolved by then. And all I'm simply saying, not that I want you to be without any legal representation, because as you know, the case is voluminous and other things. But the case must start. You see the point I'm making? At some point, the trial must start, and the accused persons must be in a position to know whether they go scot-free or not. They are acquitted or they are convicted. There must be a time for that, regardless of all these other issues. So, August 4, what is your position in relation to that date? You have expressed the hope that I hope by then all my applications will have been disposed of.
Yes, the explanation I've given you, Judge, is the context in which I look at the date of August.
All right, okay.
And I sincerely request that at the end of this session, these proceedings today, that the court makes an order that the running record be provided as a matter of urgency.
No, I will advise the registrar now. Can you make sure that the record is available to the parties? I mean, beyond that, unless I have got to order them as by way of contempt, or how do I handle it? You have been talking about the other record as well. It's their duty to provide the record, so they must ensure that the record is available. Right.
Thank you, Judge.
Mr. Esau or Mr. Shanghala, I'm just trying to go with some order.
Excuse me, Judge?
I'm asking Mr. Hatuikulipi.
Yes, Judge. I think I associate myself with the submissions of Mr. Shanghala. However, the registrar seems to have understood the challenges that we face. We can only meet August 3 if the obstruction from Namibian police and the NCS stops for us to meet with the court up.
Right, Mwatelulo, let me finish with the unrepresented accused.
Pardon?
I want to finish with the unrepresented accused first.
Yes.
Yourself.
I align myself with Mr. Shanghala's submissions. However, Judge, as you are aware, I was granted legal aid and Mr. Muroro was instructed. However, there was a hurdle that needed to be met regarding the rates. Mr. Muroro was not amenable and therefore did not accept legal aid's instructions. So as it stands, I'm back to square one without a lawyer. Last week, sometime, there was a communique that was directed to Mr. Siomunje, whether Mr. Siomunje will be amenable to be my lawyer. But however, once we checked the position, we identified that it will be conflict of interest, because Mr. Siamonja is representing Mr. Tamson Hatuikulipi and Mr. Nigel van Wyk. So therefore, Mr. Siamonja was unable to accept that as well. So as it is, my position is that legal aid will probably try and see if they can get me another lawyer.
Will what?
Legal aid will see if they can instruct another lawyer who will represent me, because I'm currently still unrepresented. I've got some documents here, perhaps if I can finish them.
Do you intend to make any other applications in the same way as Mr. Shanghala and Mr. Hatuikulipi?
No. Yeah.
Now, if they can't find a willing lawyer, what do you think will happen? Legal aid is prepared to appoint a lawyer, and the lawyers don't want the rates.
I'm sure by then...
go back to the position which I stated that at some point the trial was carried on.
Of course, Judge.
Yes. So, August 4?
Well, August 4, considering everything has happened in the perfect world.
All right.
Yeah.
So, you hope by August 4, some legal representation will have been acquired. Do you have any of your assets attached?
Yes, I am POCA, everything.
And you don't intend to make a POCA application?
Well, my estate wasn't that great for me to make applications to pay for lawyers in a trial of this nature. I mean, lawyers are quite expensive. And even if I do apply, I mean, those funds will be depleted in the first 6 months.
So you can only rely on legal aid?
Definitely.
Right, Mr. Esau.
Thank you very much, Your Worship. In terms of this joint status report, with regard to the proposed timetable for the trial to start from the 4th of August onwards, I have my reservations. And my reservation is based on the fact that, first of all, we have been in remand for the past 5+ years in custody. And I want this trial to start, and I want to know what will be my status vis-a-vis the allegations and the indictments. The obstacle that the state has brought about is the appeal on my success of accessing my means, my money, my funds, at least to honor legal counsel, to pay for legal counsel. And my position to that meeting which we had on the 17th of January was that, in fact, notwithstanding the appeal on the judgment of the High Court to access my funds, I am ready to start as soon as possible for this trial.
So, in other words, you are saying we wait for the appeal, or what are you saying?
state must withdraw the appeal, then we can start. ASAP.
But otherwise, if they don't, then we await the appeal.
Then we must be released. And then we or struck this from the roll because it's unfair, it's outrageous, it's unprofessional even. Because it has become
on release, Mr. Esau.
Yes.
I can't overemphasize. On release, you are at liberty, you and all the other accused persons, to make an application to the High Court. Setting out reasons why you think you must now be released on bail. Right. You may never know the outcome, but I can assure you there's no other way I can see you adopting other than making a fresh application to the High Court. One of the reasons would be, of course, I've been ready to, if it is your reason, I've been ready for trial. I've been counsel for 6 years or 5 years, and so on and so on. I don't think it is fair to the courts to predetermine the outcome. I think a person must make his application and see what the outcome will be, rather than say, I'm not making that application because I think nothing will come of it. I don't think that is being fair to the courts in general. Right. So in regard to that, because I raised this with you because you say if the state is not withdrawing the appeal, then I must be released. And I'm simply responding to say there's no other way to release other than a proper application to the High Court for release. Yes. Anything else, Mr. Esau?
Oh, thank you very much.
Yes. I left out Mr. Gustavo, sorry.
I don't have much to add except perhaps, I've articulated this to you before. My issue is that one cannot but start to believe that the system is designed against you. On the 17th of January, when we went to see the registrar, I specifically asked the question, around legal representation. She said that she had sympathy for us and that we needed to articulate to her what the issues were that were impeding us acquiring legal representation. And a lot of this has been said by Mr. Shanghala and the others. And now it seems that is turned around to me as the accused, where a lot of these impediments, a lot of the obstruction are not in my power. I sit in a cell 16 hours a day. There's nothing I can do. We've been saying before you, my lord, even last year, please help us with the obstruction of the police. Nothing has come of that. We then now approach the registrar, who probably, I don't know, is probably the right person. But when I asked her, I said to her, look, the court has directed that we come see you to agree on dates. She suggested that diaries be open from July onwards until I think 2026. In fact, she even jokingly said that if any of the council were looking at retiring, that they needed to postpone their retirement because she was opening up calendars until 2026. She sat there and said, look, she wants to give us time to sort out these Section 26 applications. She wants to give us time to perhaps even bring a Mulima type application. Now, my lord, you know as well as I do that the court's timetable are not in our hands. You know that a judge has up until 4 months, I believe, to make a ruling. Since our meeting of January 17th, we've not received feedback from what has happened between the curators the Namibian police, and the Namibian correctional services. So again, the clock keeps ticking. We're now hearing August 3rd. So the truth is, my position may even be the same in August 3rd. You are saying, and you said before, that this trial is continuing with or without lawyers. I'm doing my best, but my hands are tied.
No, what I'm in context, all I'm simply saying, when your best is done and you can't succeed, isn't it? A trial must be carried out. That's all I'm saying.
And I don't disagree with you.
Yes. Now, but anyway.
Where I do disagree is that you have said, the court has said, my apologies, the court has said that this is, you've referred to this matter many a times as a big matter. In fact, this morning as well you referred to it. So, in my mind, I'm saying, how does the court expect me fairly to go into a matter of this magnitude? I mean,
no, actually, I don't want it
the
that
first
way.
witness could
I
be
don't
called
want
tomorrow.
it, and then be rest assured, I don't want it that way. I want you to get legal representation, but if you can't, you see, the simple point is, can you obtain legal representation in what we consider to be a reasonable time?
Yeah.
The whole point is, I would love that each one of you is competently represented, isn't it? But if you can't procure that, well, what does the judge do?
Absolutely, my Lord. And I think
There is a question I shall deal with the state arising from all this.
Thank you.
But I understand you are simply saying you are trying your best, and hopefully by 4 August you will be.
Yes, I think I'd like to echo your words. I want to be competently represented. Thank you for that. I want to be competently represented. What I've done in the meantime, and I've brought a copy for the court, I've written back to the legal aid department to beseech them to reconsider their position. At the same time, I'm waiting to bring a Section 26 application, but as I said, we haven't received feedback as to when we can go see the curators, under what conditions, etc. So that is, it's all outside of my hands at this stage. But I agree, at some point we have to continue.
And you would agree that come August 4, you would have been afforded reasonable time.
Look, I think I've just tried to highlight to the court. Today is what? I think 11. Today is 11. In 5 days, it'll be a month since we've met with the registrar, and we still have no feedback. So, you know, it's a double-edged sword. I'm damned if I do. I'm damned if I don't. I'm trying to obviously preserve my rights as far as I can, but as I understand the court, at some point, you know, this trial has to continue. Come August 4th, if I don't have substantive legal representation and competent legal representation, well, I believe then that's the way it is. That's the way the cookie will crumble.
If we finally settle on because they haven't agreed, it was between the other two parties, isn't it? The lawyers and the state for the other accused. If we finally agree on 4 August, it will be the date of continuation of trial. Regrettably, as I say, we have to come to that. But I still have a question for the state, which I will canvass with them later. I don't remember, Mr. Shanghala. I've stated the purpose of us meeting in 2 weeks' time.
Yes, to determine.
A part of it's all of this is involved, and also the issues of confirmation that I'm not doing this, I'm not giving plea explanation, and so that we set the stage for the commencement of the trial in earnest.
Correct.
Now, is there one left out?
No, not in respect of the accused persons.
Right. There's one point I want to ask from the state, because I don't have any.
Before you get there, Judge,
Yes.
may I just get clarity? When you were engaging with Mr. Esau and you addressed the issue of release, you said you don't want to preempt issues. Do I understand it that the fact that you are not releasing us is because there's a presumption we are guilty, or what is that?
No, it's not me.
Because it sounds like that.
No, it shouldn't sound like that.
Please.
The whole point is, I said you can't preempt the courts. You see, what I'm saying, if you have an application to make,
yes,
you make your application to the court believing, as you should, and as everyone should, that the court will dispense justice.
Okay, no, it was not clear. In the context of the discussion,
I wouldn't
it really alarmed me.
preempt. If you wanted to know my thoughts, which I'm not telling you, you might be surprised. But the point of the matter is, you make your application on the assumption that the court will deal with the matter fairly, grant me bail if I deserve it, and refuse bail if in the court's opinion it's not deserved.
Right.
But what I was trying to dissuade is the kind of attitude that, well, I know the courts will say no, I know the courts will say no. You see what I'm saying? I'm simply saying any person who has a good cause to go before the court, you make your application based on good faith and on the understanding that the court must genuinely and diligently do its work, grant orders which are merited.
Great. Judge, to make the next appearance more meaningful, the one you anticipated of, hopefully you will still determine the fortnight one from today. To make it meaningful, could you, in addition to the order I've requested for the running record to be made available, could you make an order that we are given access to the curators, please?
No, that is to come to me as a
full-blown application.
I don't even know what the problem is. Let me tell you my attitude as a judge. As a trial judge, I don't think I should be involved in too many administrative issues. As a trial judge, I can't be concerned too intricately with whether you have legal representation, what is your problem in obtaining this and all that. My understanding of a trial judge is you keep out of the fray, people organize their things, the date for trial is organized, we commence the trial and we proceed. But there is an extent to which, of course, you can be involved in ensuring that people are legally represented, isn't it?
Yes,
like giving sufficient time. But
yes,
it's another thing for this judge to be involved in ensuring that you actually get legal representation or you actually get legal aid. Because those are matters handled by other people. But if an application is brought to me that there's no basis on which legal aid is refusing me legal aid, I will decide accordingly.
Yeah, no, Judge, I think maybe I miscommunicated and you misunderstood me. What I'm talking about is the obstruction we are receiving from the Namibian police and the correctional service.
But you will understand, talking of this judge,
yes, Judge,
short of an application which they also have to respond to, isn't it?
Yes, Judge.
You will have to make an application. I'm being obstructed, whether to me or to a high court judge, any other, isn't it? I'm being obstructed in this way, in that way, in that way. I want an order to this effect. That kind of application will go to the obstructors, they will have to respond, and the judge will have to make a decision.
When I made the application for condemnation in this court, we were quick to grant my condemnation.
Condemnation for what?
For my failure to file the pleadings which we were supposed to file in the separation for trial, if I'm mistaken. We were obstructed. I have time and again come here to court, stood here, made the representations to you. I then filed a condemnation. The reason I did that was so that we could zone in that application to the issues. Regrettably, the court was quick to just grant it. The state got away scot-free. When I come back to you, and not only myself, but 3 people talk to you about this issue, I would have thought, in my little sense of understanding of the function of a judicial officer, is to say, wait, something is wrong here. The registrar was minded to say, wait a minute, hold on. Prosecutors, what are you telling me? You didn't tell me this and you didn't tell me this. We gave her documentation. She read, she said, listen, write to me, I need to address this issue. I was of the mind that perhaps that record would have arrived to the judge, would have perused it, and said, listen, my sense of justice and the oath that I took in this country requires me to look you and say, what is happening beyond here that affects a fair trial that I'm not aware of? Is there something that I need to address? And then I stand up from the dock where I am and I say, Judge, this is the situation. And then you say, wait, let's adjourn, let's call so-and-so, so-and-so, let them stand before me, let them address me, so that we can have a fair trial. Are you telling me that this court is emasculated from doing that? This is a travesty.
Well, when you use those words, the point is not a travesty. I've told you that if you want this court to make a decision, you make an appropriate application properly. I don't know how I should emphasize that. If you just say, can you make an order for this, and I've said I'm not doing that. I want things procedurally done. If you have an issue to raise against any party, against any obstruction you receive, make a proper application. I will consider it.
I've heard you, Judge. You've heard me.
Yes.
Thank you.
Now, coming back to the state, I want to be very clear whether if a party whose assets have been seized under POCA writes to the state and asks for part of his funds to be released to pay legal representation, does that matter have to go to court in every case?
My Lord,
in other words, if I may finish my question, is it not possible for an amicable resolution of that issue to be arrived at? Is it always to be that you must make an application to court and then the court will decide? If for instance, Mr. Shanghala applied to you by way of a letter to say, I would want to obtain release of money to pay legal representation, may I know what your attitude is? Are you telling me that the state cannot say, well, we think it's a reasonable thing and find a way for an amicable settlement? Is there no way, Mr. Marondezi?
my Lord, to answer the court, my Lord, is that the first thing to be looked into, my Lord, is why was this property seized? That brings into into play the provisions of POCA.
Mm-hmm.
POCA is there to make sure that any proceeds of crime should not benefit the perpetrator. That's why the property is seized.
Mm-hmm.
And the property is seized not because the state on its own just goes and seizes the property. It applies to a court of law that we believe these are proceeds of crime, and the accused person should not benefit from the proceeds. And the court gives an order that this property should be preserved. After that property has been preserved by the court, no party, even the state which applied for that preservation, can do anything with that property without leave of the court. That is why there's a provision of Section 26 which provides what should be done for that property to be released. Because the state here is
to come to any definitive view. All I'm simply saying, if a party comes to you and says, well, my property is restrained, I'm coming to you because I want legal representation, I want part of my property to be released to pay for legal representation, and of course he indicates how much he needs and so on. Are you saying, short of going through the court process, that cannot be subject to a settlement between the state and the individual?
The state cannot, my Lord, settle with the accused person and is prohibited by law to negotiate anything about that property which is presented by the court. There's only provision in law what should be done with that preserved property. The state cannot deal in anything with that property.
No, Mr. Marondezi. I think let's focus on the issue I'm concerned with. Section 26 provides for what? For a person whose property is under restraint, isn't it?
Yes, madam.
To apply to court.
Yes.
For release of that, whether, let's talk about funds, isn't it?
Yes.
For release of portion of his funds.
Yes.
For legal representation.
Yes, madam.
And my only question is this. When a person approaches the state saying that, can you release, say, 2 million of the funds I have, which are under restraint, so that I am able to pay my lawyer in a case, in a criminal matter I'm facing, that is not capable of an amicable resolution without a court order. That's
yes.
my only question.
The question is, and the court order provides what should be how that property should be dealt with.
If an accused person wants to make that application, who does he cite as the respondent?
Says the state as a respondent.
Now,
and in that application, my lord, if the accused person complies with the requirements for release of that property, the state will not oppose. Because there are predeterminations, my lord, of what should be complied with. I would refer
yes,
so
all of that, I am simply saying, let's suppose you receive an application today. You look at all the requirements for Section 26, isn't it?
Yes.
And perhaps you say to the applicant, well, if you can satisfy us on this, that we need a little more information on this. Are you saying it's not possible for the state to say, just like they may not oppose the application, for the state to say, well, on the information you have given us, we don't oppose your application and the matter is resolved by consent?
Okay. The court has put in a new dimension to the question, yes. That if they comply with the requirements of Section 26 and they've left a few other issues which we can need to be clarified, that is something else, my lord. That can be done.
All right. At one point I'm trying to push for things to move, right? In this trial. In 2 weeks' time, I would want to be assured from the state side that I don't know what interaction you can have with the persons who want release of their funds, that there is no possibility of an amicable resolution of the issue. Because if there is, and I'm not saying by you as in your capacity as prosecutor, but I'm talking to you, this court would want to be assured that there is no way, absolutely no way, in which that issue can be resolved in the manner that I am indicating.
I'm hearing, my lord. Yes. But what I want to add, my lord, is that there's nothing that is, and the state has never stopped the accused persons from filing applications which are compliant with the law. If, as long as they are compliant with the law, the state is a duty to obey the law. They have to comply.
Me asking. Yes. I'm talking about a process of an amicable approach.
Yes, madam.
Resolution of that.
As
problem.
Long as they file proper applications with proper reasons which meets the law, the state will look into that matter.
And will not oppose.
If the state is satisfied that they have complied with the requirements, that is it, madam. But if it is just simply asking that release my money for legal representation,
but
no.
I say this not because I want the state to give them their money. Now, let's assume they applied the Mlima way.
That Mlima way.
No, I'm just trying to see the balance between the Mlima way and the release of funds under restraint. The taxpayer would have to pay for them, isn't it? If they succeed the Mlima way. Legal aid is the taxpayer, isn't it?
Yes. But it doesn't necessarily...
No. I'm just trying to try and because I have no other opportunity to do it.
Yes.
I'm just trying to say, can we balance these things and see how the Section 26 applications. Mr. Esau has said, why don't you just abandon your appeal? There's a court judgment already. But I'm not saying that legally he is correct. But of course, it's up to the appellant to abandon his appeal if he wants. But I'm not concerned with that. All I'm simply saying is, it is necessary, in my view, that this issue be resolved, if it can, even
at page, I think, 3 thereof, paragraph 1b, exactly what you say here. The registrar offered. I just want to read it to you. She even confirmed it in the meeting of the 17th of January. All defense counsel, as well as the representatives from the prosecutor general, indicated their willingness to enter into round-table discussions with the representatives of the POCA division, 1, facilitated by a court-accredited mediator, 2, in an attempt to limit the issues which may be in dispute in an application for the release of funds for purpose of legal costs filed by the defense, 3, all present agreed upon Mr. Marinus Nederlof as an independent for the Office of the Judiciary for permission to pay the mediator's fees in respect of from state funds. That is now, and she confirmed this again in the meeting we held. She had received the money, but the problem, Judge, and this is why we keep saying that we are not delayed that we have. But Judge, let me lastly Mr. Marinus has hit the nail on the head. It has to be a proper application brought before the court. Mr. Hatuikulipi went to court. Last year, he got a judgment. This is not a proper application. Come with your proper application. Come with your tax information and your tax liabilities. We have tax liabilities. They need to be resolved by the curator who is administrating our estates. We need to go see the curator. The police, NCS will not allow us. They need to be apparently. I don't know what we will do. We get sent from pillar to post. When we come here, it must be a substantive application. We cannot talk about a fair trial if these issues are not addressed. This is the point. And the point that we've been making is falling on deaf ears. So, Judge, if we really want to be doing something for next week, and when we come back on the 4th of August, these are the issues you have to address. The obstruction must end. For crying out loud, even the Nuremberg trial, where they killed 6 million Jews, they weren't treated this way. Why are we being treated this way in a democratic country? And Mr. Marondeza says, why are the property attached? My mother's house, my mother died in 1988 in a bomb when this country was in the liberation. Why is it attached? Is it a proceed of crime? These are the issues. They attach the entire estates. These are the two hamstringers. So what we are saying, judges, if you allow us to go and see the curators, sort out our issues, we'll be more than ready, possibly when we come here on the 4th of August. If we try to skirt around with the niceties of bring this and bring that, we are not taking decisions. Yeah? The late Gengob used to say, black people, you've been given the power, then you skirt around it. I need. This is what is happening here, with the greatest respect. Either you believe in the fiction or not. The fiction is you have the power, deal with it, handle it, use it or not. And then we can go ahead and say, look, proceed with your case. There's no justice there. It's not a court of justice anyway. It's a court of law. And he wants a law. He wants procedurally this application. It must be on this paper. It must be that. That is what you are telling me. This is unfair.
Mr. Shanghala, you are going beyond the scope of what I was addressing with the state.
Can you imagine after 5 years of frustration, it may happen to a human being? You should try it once.
Well, yeah. For me, as I have said many times before, I am completely sympathetic. But the processes that have to be followed, if they have processes of law, unfortunately they have. Anyway, the point I was canvassing with him is simply for them to come back to this court and advise that that route is completely shut out. After due consultation, because the state, if we are talking about the state, I'm sure we are talking about the same the same big organization which involves those who deal with the POCA, and it's all part of the state. So, coming back on there's no objection to the 21st, is it?
Yes, my lord. The state has just one request before the date is set on my lord. We have a witness outside who has been coming to court since the 4th of February. We want to call him so that he can be excused for the purpose of PE, so that he can be able to claim his expenses. If you may call Dr. Moses Maungiriri.
I mean, excused for today.
I don't know. I don't know whether we warn him for the 23rd or we warn him again for what.
No, you will be excused until a firm date is...
Yes, if you may call him.
Yes.
Moses Maungiriri. Moses Maungiriri.
This is exactly the issue I'm talking about. I addressed you. We should be able to be alerted. Who is the witness? What statement are they coming to testify to? What is the document? I'm learning of it now. Sincerely, this is trial by ambush or what? This is not proper. So if you were prepared for us to commence today, I would have learned, and this is fine. This is not proper.
Yeah, but those are the things we say we must put in order in 2 weeks' time. All these issues must have some direction when we meet on the 21st.
Indeed.
For the state, all I can say is that when a matter has been questioned, unless you have some advance notice of what the attitude, what the judge is going to do, you must be ready. It was quite open for me to come simply and say, we have finished the plea proceedings, can you call your first witness?
That's why we had a witness in attendance.
Because you have to be ready. Yes. Otherwise, unless other things happen like they've happened, I would have simply said, call your first witness if the state is ready. But that is not to saying about being informed.
Yes,
so that one,
my lord,
to the extent...
Can you be informed now? This will be the first state witness who will be called.
You see?
You will know that.
You see?
We will not call another witness before.
Yeah, but I don't want us to argue over a witness who is not even before the court properly.
Yes.
I mean, your witness is not been called by the court, isn't it?
Yes.
Your witness is such a witness as you can tell that, look, the matter hasn't started. But the only thing you said to me, which seemed to make sense, is that if I don't recognize his presence, then he's unable to claim his witness expenses.
Yes, my lord. One thing I should inform the accused persons is that we'll give them a couple of witnesses whom we expect to be calling, but we'll not tell them that we are going to call this witness and this one second and this one third, this one fourth, because we see how our case will be going.
No, that is a question of strategy, but I think broadly you will be addressing his concern that we need to know who will be called, isn't it?
Yeah, we'll just give them the full of witnesses we're going to call, not the order we're going to call them.
All right.
Sorry, Judge.
Yes.
When he says not the order, I'm not saying tabulate and give us a list that number 35 on the list. But what I do expect is reasonable notice is given that on this date that witness is coming. Surely that should be something that happens in this court.
I suppose you will address that as well. I mean, you can't just say you have to show that people will be called. All he says he can't do is to give you the order in which he is calling them. But once the trial starts, we should be able to be more transparent and open about what we are doing.
We should, including, Judge, the updated, remember when we were going through the plea, the indictment, an updated indictment was supposed to be provided by the state. They committed to doing that. They haven't done so. Remember that in a status report we prepared to you, The witness statement I requested from them is still not forthcoming.
Yes.
Really, sincerely.
Right.
I'm sorry to these things. We should have dealt with the pre-trial.
No. The point of there, and I understand to stages in every trials and for your expense formal different ways in every trial, and we deal with them until you are advised by the as we. Yes, you are excused. The state will advise you when the time comes for you to come and testify. Any objection to 21st?
Yes, Judge.
Yes.
The 21st, the matter that relates to the constitutionality or not of this courtroom, the 21st is being heard. We're arguing before Justice Mwatelulo. So if you will excuse me, then I can go there together with my co-applicants, and you can continue. Other than that, that date is committed.
All right. Can I leave it to you, the date around the 21st? Because remember, Mr. Siamunyu had said is available. Can I get your matter is there on the 21st only, is it?
Yes, on the 21st only. There's only arguments that are outstanding in respect of a interlocutory matter.
What other date do you have in mind?
My Lord, if you can indicate maybe the time, then we can maybe slot this matter for the afternoon.
Fine.
Yeah, I think let's do it for the afternoon.
For the afternoon, yes, ma'am.
Yeah.
2:30.
Yes? No, he said 25. Mr. Siomunji talked about 25th. Yeah, I'd noted it. 25th. You are fine with the 25th. Mr. Siomunji indicated 25. I can see from my notes. 25 is fine.
The state is okay, my Lord.
On that day, I would want to be able to state when this trial will commence.
Yes, the court, please.
And while we will come to it, I would just indicate that in my view, when the date for trial has been set, the trial will have to proceed, apart from other unforeseen circumstances. So I would, with all the things we have discussed, which you have to look into, starting just for the summary, the issue of plea explanation, if there is any, a response to the pre-trial memorandum confirming the positions, the issue of commencement of trial. I think that's one of the main issues. Taking into account the issue of legal representation of the unrepresented accused. But the date will be to firm up on a date of trial.
Judge, will the court order please reflect this last part of your order specifically so that we may be able to take heed into...
You mean in respect of legal representation?
No. Just the issues that you've tabulated so that the court order is clear when it's issued.
Yeah, I don't know whether I want to do that. I don't know whether I want... The point of the matter is these are discussion issues as far as I'm concerned. They can come out, I can do that. There are issues, like I say, so that we finally get a pre-trial memorandum and I've mentioned legal representation.
So we won't deal with the issues that need to happen between that date, so that the other issues I've addressed are also.
Yeah, well, to the extent that we will, we are meeting on that day. So if it is possible to do that, we'll do that. If it is necessary for us to do that. The whole point is, I say, is to 4 August.
Okay.
By agreement of the others where you were not involved, isn't it? Right. So I am not imposing that yet. I'm saying let's look at all the issues that remain outstanding, and then we firm up whether we agree with them or not. If we don't adjourn to 25 February 2025 for final on the continuation of the trial in this matter, especially the date of continuation.
Yes, the court principal.
Determine